more minutes.
Yes. The witnesses, I think the witnesses can switch on their cameras because it's the courts and they're normally in courts.
Yes, they should. It's their case. And
Not
your phone. Let me just remind you so that when you don't forget, all phones should be switched off.
My phone's switched off. Thank you, my lord. Mr. Udochi, I don't know, your camera sitting, we can't see you. Aha, you're seated. You need to, yes, we need to see you properly. The camera is looking upwards. Ah, it's much better now. Right, right, that's it. Please tag this.
So can everyone look through their names and correct their names? I can see somebody, we have two cheeky Palikis, Esquire.
Right, go and correct.
Mr. Udochi, your name is correct. Leonard Silk, your name is correct. Desmond, you're a witness.
Change the name, which is.
Are you a witness for the claimant or defendant? I hear your mouth. Your mouth is
for the claimant. For the claimant.
Okay, so I'm doing claimant witness.
Yes, you can change. Aha, change your paleke, the lady. She's our witness.
Yes.
For the defense.
Okay, what's your name? Our witness. Your first name.
Kim
Her first name is Lee. Okay.
Is what?
Yes, Landley. Go ahead.
Kim.
So you are Kim Landley.
Landley, yes, Kim Landley.
And you are Hassan Tauban.
Yes.
All right. Thank you, Lordship. Okay, so my deputy registrar has joined. He would handle.
I hope it's not robed.
Your Lordship is not robed.
Acting registrar, I'm going to, on the dot of 9, I'm going to walk into the courtroom, supposedly that of the, okay?
As your Lordship pleases.
Precious. Tell me, where's the case? I need to bring out all this for me because are you helping them?
Yes, I was trying to fix this budget.
Which one, chicken? It's okay because we don't, it's not going to be a word.
Okay, yeah. Okay. No, but they must hear the sound that the court is coming.
No, so you can hear me clearly, correct?
Hello?
Yeah, so you can hear me clearly.
Okay.
You want us to wait?
No, I said they can't wait. They're already
Wait, okay.
Your Lordship, Mr. Nonso Anyasi, who is the registrar, who is actually going to be hands-on, would continue as we've agreed, Your Lordship. I won't sort out the streaming on the back end, but Mr. Anyasi would continue on this end.
It's a minute to 10 now. I think it's a good time for us to proceed now. The court is now in session. We are the High Court of Justice before Honourable Justice Edigin. May all rise for the court.
Registrar, call the case on the list.
Yes, my lord. The first case on the court list is suit number BRH1-2021 between Rasprotec Nigeria Limited and Hespa Nigeria Limited. My lord, the parties are absent, my lord.
Appearances.
With profound respect to my lordship, E.A Udochi, sir, appearing with me are Mrs. M.O. Eghobamien and S.O. Uni Esquire. I announce our appearance for the claimant on record, sir.
Thank you very much, Mr. Udochi.
My lord, before I start, may I seek your lordship's permission to allow us sit down while we address your lordship? It's just a bit more convenient.
Sit down. Then all counsel, everybody will come sit down. I thought after I took the vow that it was this. Yes.
My lord, thank you, my lord. May I introduce myself? My name is Osaro Eghobamien.
Yes.
And appearing with me is Mr. Chike Okpaleke.
Yes.
We both appear for the defendant, my lords.
Yes, counsel, I have seen your pleading. The famous case is for a breach of contracts, payment for contracts entered into between both parties. The statement of claim is here, the statement of defense is here, and the reply to the statement of defense. However, I observed also that there is a motion filed by the claimants for this court to stay proceedings pending the proceedings between the parties as entered into in the agreements, contract agreement between the parties. And the proper thing would be to hear the motion first. Are we ready?
As the court pleases, if it's convenient to your lordship, I would like to proceed with the application which your lordship has just identified.
Yes. Mr. Udochi?
My lord, we are in a position to proceed. We had filed a counter to the application, subject to your lordship's convenience.
Yeah.
And we are ready to oppose the application.
Okay. You want Mr. Obama, you file your plan point of law.
Correct, my lord.
Okay. Can we proceed to the motion now?
Yes, my lord. My lord, the application before your lordship is dated the 1st day of March, 2021.
Yes.
The application is brought pursuant to Section 4 and 5 of the Arbitration and Conciliation Act, and under 40 Rule 2 of the High Court of Edo State Civil Procedure Rules 2018. My lord, the application seeks one prayer, or two, I would say, but one principal prayer, which is staying the suit pending the determination of the arbitration proceedings between the parties. We obviously seek a broader relief for your lordship to grant any orders that your lordship considers fit in this circumstance. The grounds upon which the application is sought is disclosed on the motion paper, and the application is supported by an 10-paragraph affidavit, I beg your pardon, sworn to by Abiola Emeka Hassan. My lord, the application is also supported by written arguments. The registrar will just kindly disclose the written arguments. Yes, thank you very much. My lord, although we have dealt with a number of the issues, may I seek your lordship's leave to emphasize one or 2 points in particular, and may I be guided by your lordship. I would need perhaps 10, 15, 20 minutes, but I'd like to know how your lordship's mind is working in terms of time allocation, with the greatest respect.
Yes, Mr. Eghobamien, you're asking for some time to highlight issues in your motion. I won't give you more than 3 minutes because I already have them here. So you can quickly go over that. That's enough for you.
My lord, did my lord say 3 minutes?
Yeah, 3 minutes.
Well, my lord, the rules provide 20 minutes, but I'm guided by your lordship's order, but I would just plead that the second point I want to raise is one that is fundamental and perhaps not adequately covered. And I'm going to be citing an authority which is not now included in the brief. I would submit it to your lordship. So, but I will start, my lord, and hopefully I'll be guided as we proceed.
20 minutes, that's too much. I'm going to have reached the time.
As the court pleases.
Yeah, so maybe, but I'll give you 5 minutes, so just go ahead.
As the court pleases.
Yes.
My lord, the simple issue is whether or not your lordship should refer this matter to arbitration.
Yeah.
And the simple answer is provided in the contract, clause 11, which states that matters of this nature should be, which states clearly, the clause expressly provides that this contract is a contract that should be determined if there's a dispute in arbitration. The claimant has, however, proceeded and ignored that clause. Of course, we anticipate the arguments of the claimant, as is recorded in his brief, that because the defendant had filed a statement of defense, the defendant had taken steps, and therefore your lordship should proceed with the matter. In other words, stay of proceedings should not be granted. My lord, the principle of law is that it is not in every case that a defense is filed that the court exercises a discretion not to refer the matter to arbitration. My lord, there are a number of cases we've cited which indicates that even where a defense has been filed, the court has exercised a discretion to proceed with the matter. The filing of a defense is a relevant fact to be taken into account. It's a paramount fact to be taken into account, but it is not conclusive. Your lordship still has a discretion as shown in Section 4 of the Arbitration Act. Now, the reason why I would commend that this matter be referred to arbitration is because of the peculiarity of the issues in this case. The issue clearly is that the defendant failed in its obligation to meet a payment schedule. But the reason he failed is as a result of the pandemic. And my Lord will see from the reply to the statement of claim, and this is why it was important to file the pleadings. My Lord will see from the reply in the statement of claim that we are saying that where COVID, the pandemic, is the reason for failing, we're urging that this is a contract which is affected by force majeure. In other words, it's the loss will lie where it falls, and that was provided in a contract. Now, the principle upon which one decides whether or not a case of this nature is affected by force majeure was stated in an English case which dealt with a similar clause, and I'll just refer your lordship to it. The principle was stated in a case in the United Kingdom is the Financial Conduct Authority against a number of insurance companies. My Lord, there, and I will submit this authority.
Mr. Oghobamien, that's the extra authority that you want to submit for this agreement?
My Lord?
Is that the extra authority you want to submit for this argument?
Correct, my Lord. That is the extra authority that I like to submit.
Can you come again with the name?
Yes, my Lord. It is the Financial Conduct Authority against a number of insurance companies, and I will just state the first one there, is Argenta Syndicate Management Limited. Argenta Syndicate Limited is the appellant, I beg your pardon, against the Financial Conduct Authority and others, respondent. And it's reported, my Lord, in 2020, EWHC, it's an English report, 2448, commercial courts, 2448, my Lord.
Come again, yes,
I said it is 2020, EWHC, high courts, commercial courts, my Lord. EWHC 2448.
Okay.
My Lord, in that case, it's one of the few cases that's gone to the Supreme Court in England after the COVID crisis. The courts indicated the test to be determined whether or not this contract is affected by force majeure. That test is an objective test, not a subjective one. It's an objective test. Now, what's the relevance of this? The relevance is that if it's an objective test, in other words, how will a reasonable person looking at the contract interpret the language? It is not subjective to the parties, but it is objective in terms of a bystander looking at it. I'll just read the portion out to bring the point home better. There is no doubt or dispute about the principles of English law that apply in interpreting policies and contracts of this nature. They were most recently authoritatively discussed by this court in Wood and Capital Insurance Services in the judgment of Lord Hurge, and is set out in that judgment of the court below at paragraph 62 to 66. The core principle is that an insurance company, like any other contract, must be interpreted objectively by asking what a reasonable person with all the background knowledge which would reasonably have been available to the parties when they entered into the contract would have understood the language of the contract to mean. My Lord, if indeed the tribunal is going to be considering what the bystander, what a reasonable person would, how a reasonable person will interpret the words in the contract, how better is it that this contract be referred to an arbitral panel that has the opportunity to interrogate facts without the restrictions of the Evidence Act. My Lord, there are no principles of law on what has happened in terms of the contract where COVID affects it. I believe, therefore, that looking at the Arbitration Act, the presumption is that matters be sent to the arbitral panel. But it's even more important that where there is an intervening factor like COVID, and where the principle upon which it's to be decided are matters of fact, then it makes more sense, with the greatest respect, to send it to an arbitral panel that can investigate and interrogate the facts. Now, this is a criteria which ought to be taken into account because, as I did say earlier on, the court has a discretion if one looks at Section 4 as to whether or not to send it to arbitration. Whereas it is correct that filing a statement of defense may be considered taking a step, but as I did say earlier on, that is not conclusive. It is only a paramount factor to be taken into account in deciding whether or not.
Begin to wind up, please.
Yes, my Lord. It is a paramount fact. The filing of a defense, which is what my learned friend has concentrated on, the filing of a defense is only a factor. Your Lordship is required to exercise a discretion. If your Lordship relies on other precedents to limit that discretion, with the greatest respect, that will be an improper exercise of discretion because that will be limiting the discretion of the court. To the extent that's a discretion and COVID is an intervening event, and indeed one that the parties may never have contemplated. In fact, the force majeure clause may not have covered the issue of COVID. COVID did not cause the crisis. It is the government's intervention that caused the crisis. I think these are matters of fact which ought to be considered by an arbitral tribunal. I thank your Lordship.
Thank you very much. Mr. Udochi?
My Lord, the claimant respondent is opposed to the application.
Yeah.
And in furtherance of that opposition, my Lord, I said the claimant respondent is opposed to the application of the defendant applicant.
I heard you, yes.
And in furtherance of that opinion, counter-affidavit consists of 10 paragraphs. This is deposed to by Olani Adeoye. Olani Adeoye, a litigation assistant in the law firm of Udochi and Udochi. And Lord, in accordance with the rules of court, he had filed a written address accompanying the counter affidavit. We beg most respectfully to adopt and rely on written address as our submissions in opposition to the application of the applicants. And Lord, with great respect, we just wish to highlight 2 or 3 points.
5 minutes.
Firstly, my Lord.
5 minutes.
Yes, my Lord.
Go ahead.
My Lord, as I said, with greatest respect, I want to highlight 2 or 3 points, my Lord. My Lord, the application has been brought under Section 5 of the Arbitration and Conciliation Act. Section 5. My Lord, that section specifically provides, and I quote, that any party to an arbitration agreement may, at any time after appearance and before delivering any pleadings or taking any further steps in the proceedings, apply to court to stay the proceedings. My Lord, the defendant applicant has filed pleadings in these proceedings. So we submit that the filing of pleadings is a waiver of the right to arbitration. Once pleadings are filed, the right to arbitration is waived. My Lord, the essence of this is that we submit that the affidavit in support, paragraph 8 thereof, has stated that the defendant is ready and willing to do all things necessary for prompt resolution of the said dispute between the parties through the conduct of proper arbitration. There is nothing on record to show that the defendant has put the arbitration process in motion. There is no letter to the claimant inviting the claimant for arbitration. Nothing on record. The mere deposition of willing to do is not enough to induce this honorable court to grant a stay of proceedings. Well, I will submit that, in all honesty, the applicant has waived his rights, joined issues on the pleadings with the claimant, and we refer to the authority cited by the NSC, and we say with due deference that the issues raised in that authority are a defense on the merits, to the case of the claimant. It's not for purposes of allowing an arbitration to move. So we submit that based on the pleadings and issues joined, the matter should be submitted for trial. We beg to oppose.
Thank you very much, Mr. Udochi.
Thank you, my lord.
Mr. Eghobamien, you filed a reply on points of law.
Yes, my lord. Yes, my lord. Yes, my lord. My learned friend had referred to the Arbitration and Conciliatory Act, but he read just a portion of it. May I, with the greatest respect, refer to Section 5.2 of the Act, the Arbitration and Conciliation Act. And this is what it says, my lord. After the portion which my learned friend read, I then read the relevant portion. A court to which an application is made under Section 1 of this section, in other words, if there's an application for stay of proceedings, the court may, if it is satisfied that there is no sufficient reason why the matter should not be referred to arbitration, in accordance with the arbitration agreement, make an order staying the proceedings. My lord, that portion clearly gives to your lordship the discretion I was talking about. And that discretion obviously means that the fact that a statement of defense has been filed, and I refer to another authority, which is in a brief. A statement of defense was filed in Britannia. I referred to it in our brief. Statement of defense was filed, and yet the court held that the matter could yet proceed, the matter could be referred to arbitration, notwithstanding the defense having been filed. The point, my lord, is that the court has a discretion. COVID is an intervening factor, which is taking all of us unawares. No one anticipated this particular situation, and therefore, each contract must be interpreted against that background. In other countries of the world, they've introduced legislation to deal with the COVID era. We now have to wait for source material from my lords all the way to the Supreme Court. But it is important that the factual bases are well established. And with the greatest respect, since the parties have always intended that the matter be referred to arbitration, I would contend that having regard to the test that is now being, the test that is being imposed, the test that is being used to determine this issue, the arbitral panel is the best place, and that is a proper exercise of your lordship's discretion. In other words, there are points that your lordship should take into account which had never come before any other judge before. That is a good reason. And because the Arbitral Act provides for your lordship to take into account that discretion, to take into account a discretion, notwithstanding the fact. Paramountcy will be given to the fact that pleadings had been filed, but that is not conclusive, my lord. And that's the point I'm making. And the Arbitral Act supports my position with the greatest respect.
Thank you very much, Mr. Robert. Having heard counsel for the parties on this motion, I will rise for 10 minutes to write my ruling so that we'll know whether we're going to trial or not. So the court will rise.
As God pleases.
Thank you for
Court. So while we wait for the court to write its ruling on the application which has just been argued, may I use this opportunity to inform our esteemed viewers who are viewing these proceedings live on YouTube and on other social media that the idea behind this project is to demonstrate to participants in the judicial sector that we can actually do virtual hearings in Nigeria. That notwithstanding whatever technological restraints or whatever technological constraints that we may have in this country, that we can adopt it. We are starting from somewhere, and right now we have just tried to take applications, and we could see that everybody could watch and see the applications that were being argued by the parties. And that is to show us that whatever shortcomings that we feel that technology may have in terms of the judicial sector, that we can overcome this. And it's based on how the ruling goes. If my lord grants the application and says that the matter should be referred to arbitration, that will terminate the matter. But if my lord rules otherwise and says that the matter should go to trial, we will have the opportunity of seeing live trial conducted via Zoom with witnesses, and we will see whether my lord can be able to actually observe the demeanor of witnesses. So that's just the idea behind this project that was instituted by the Justice Reform Project, acting in partnership with the Edo State Judiciary. And just about last year, we did a similar project in Lagos State before the High Court of Lagos, and it was quite successful because we had a similar case, and you could just go on our YouTube page to watch the videos of the first session that was held in Lagos. Thank you.
Because I sent it to him.
It's mine.
Very big seat. Should we just sit?
You almost say that. I'm just going to I'm calling.
Counsel, I hope you are seated after the bar, so you don't keep standing. Can you hear me, Counsel?
Yes, my lord.
Okay.
Yes, my lord.
I've just written a short ruling on this motion. I'll go straight to deliver the ruling. The present application was filed by the defendant, ESPA Nigeria Limited, hereinafter referred to as ESPA, and seeks an order staying the proceedings pending arbitration. ESPA's application was brought by motion on notice dated the first day of March 2021, and supported by 10-paragraph affidavit deposed to by Abiola Emeka Hassan, and a written address dated the 1st of March 2021. The claimants, Rascotec Nigeria Limited, opposed the grant of this application and filed a 10-paragraph counter affidavit deposed to by Tolani Adeoye and the written address dated the 5th of March 2021. In reply, HESPA filed a reply on points of law dated the 11th of March 2021. All processes were adopted by Counsel and oral arguments were taken by this Honourable Court today, the 29th of March 2021. The issues before the court are fairly straightforward and delineated. The issues presented by the parties are adopted verbatim and considering same, the primary question which the court will determine is whether, considering the circumstances of the case, it is proper to grant an order staying proceedings and referring the parties to arbitration. The court will now proceed to consider this issue having regard to the applicable law, the evidence adduced, and arguments of counsel. HESPA's claim in this regard is relatively straightforward. The underlying agreement contains an arbitration clause, and as such, in accordance with the agreement of the parties, HESPA has urged this court to refer the matter to arbitration and that proceedings herein be stayed. Rascotec objects on the simple premise that HESPA, having filed a statement of defense, is not entitled to the prayer sought. HESPA's reply takes an interesting turn and asks this court to exercise its discretion and grant the application, despite the step taken, and urges the court to consider the intention of the drafters of the ACA, Arbitration and Conciliation Act, vis-a-vis the rules, the moral provisions under the rules and principles of international law in deciding this application. On the material facts of this application, there is no dispute. HESPA has filed a statement of defense and as such has taken a step or submitted the first statement on the substance of the dispute under the applicable law. Accordingly, the question before this court is purely one of law. That is, whether the court ought to grant the present application despite HESPA having taken a step in the proceedings. The court, having considered the submissions of counsel, is minded to exercise its discretion in favor of the claimant and refuse the present application, and so holds.
As a court, please.
On the effect of taking a step, the court notes that under our laws, the notion of taking a step is rooted in the contractual concept of a waiver and the doctrine of estoppel. Essentially, courts have held that taking a step amounts to a waiver of the defendant's right to compel the referral of the dispute to arbitration, and that having taken a step in the proceedings, the defendant is stopped from relying on an arbitration agreement it had itself reached. See Federal Ministry of Health and Others versus Daston Nigeria Limited, 2017, Law Pavilion, Electronic Law Report 43621, the Court of Appeal decision, pages 17 to 19, and paragraphs D to B, per RBE JCA. Accordingly, this court holds that HESPA waived its right to refer the dispute to arbitration, having filed its defense. Also, the court rejects HESPA's argument that this court is mandated to refer the dispute to arbitration in accordance with principles of international law and dismisses its reliance on Abacha versus Fawahimi, 2000, Law Pardon Electronic Law Report 14, Supreme Court decision. Hesper's argument that the UNCITRAL model law and the New York Convention supports its argument for an automatic stay of proceedings is unfounded under our laws. It is strikes that international instruments are only binding when ratified. See section 12 of CFRN. Furthermore, even assuming the applicability in original form, the remaining model instruments which are to be adopted and modified as the contracting states please. Accordingly, a reliance on the model law provision is unavailing. The court also rejects Hesper's reliance on other 22 of the rules as its justification for filing his defense and taking a step prior to filing the present application. Hesper has argued that it was mandated to file his defense before he could bring the present application. It is on this basis that Hesper asked the court to grant his prayer for a stay pending arbitration. The court, having reviewed the said provision, finds that it does not support this position. Hesper's arguments ignore 22 Rule 3, Sub 2 of the rules, which specifically caters for application of this nature and states that the abolition of the demurrer rule shall be, I quote, without prejudice to the Arbitration Act or any other law under which a defendant must apply for a stay of proceedings before filing a defense or other statement of case on the merits, unquote. To this extent, it is this Honourable Court's considered view that there is no merit in Hesper's reliance on the said provision. The court has reviewed the processes before it, particularly the statement of defense, and notes that Hesper, in any case, failed to, as required by other 22 of the rules, raise the point of law that is still proceedings in the statement of defense. Accordingly, even if the position of the law as argued by Hesper was correct, the court remains unconvinced by Hesper's arguments that it filed its defense because it was mandated to do so by the rules. Furthermore, the present motion was filed on the 1st of March 2021, more than a week after the defense was filed. The court accordingly finds that at the time the defense was filed, Hesper's intention was not to uphold the arbitration agreement, but to submit to litigation. The present motion represents a fresh proposal to arbitrate, which can only be given effect with Rasputin's consent. This is missing, and as such, on this point, the application must fail. This court accordingly holds that this application is unmerited, and as such, the prayer for stay is hereby refused. The matter will now proceed to trial and is adjourned as such. So, the defendant's application dated the 1st of March 2021 is accordingly dismissed in its entirety. Thank you.
The court pleases.
The court pleases.
Mr. Udochi?
Yes, my lord. I am subject to my lord. We will not ask for cost. We're interested in getting our money back from cost.
Okay.
We are grateful.
Now we are going straight to hearing this matter. The next case.
Yes, my lord. We are grateful to the
the motion has been dismissed.
Yes, my lord. We are prepared to proceed to trial if my learned friend is prepared.
My lord,
we looked at the pleadings and the pleadings you are front-loaded. Each party has a witness each. You have just one witness each.
That's correct, my lord.
Claimant? Claimant, are we ready to proceed?
That's correct, my lord. My lord, subject to your
Witness in the box.
convenience. Subject to your convenience, we'll proceed, sir. We'll call on
Who is your witness? Call the witness, please.
the MD of the claimant.
Yes.
Yes, my lord. Our witness is in court now.
Yes, Registrar, administer the oath, please.
Witness, please, do you want to swear or to
Registrar.
affirm?
Affirm.
Okay. Okay, please say after me. I, Mr.
I, Mr. Nassan Tauban.
Hold on, is the witness stand? The witness should stand and affirm.
Properly guided, my lord. I, Mr. Hassan Tauban.
Hi, Mr. Hassan
With your
Tauban.
hand. With your hands. Right hand should be up. Yes, that's better. Thank you.
Okay, properly guided, my lord. I, Mr. Hassan Tauban.
I, Mr. Hassan Tauban,
Do solemnly affirm
do solemnly affirm
that the evidence I shall give in this case
that the evidence I shall give in this case
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you.
Yes. Please tell this.
Let him sit down, please.
We're grateful, sir. Now, please tell this honorable court your full names.
My name is Mr. Hassan Tauban.
Where do you live?
I live at kilometer 5, Lekki Epe Expressway, Lagos.
What do you do for a living?
I'm the managing director at Raspotech Nigeria Limited.
Do you recall that on the 27th day of January, 2021, you posed a written statement on oath before the honorable court?
Yes, I do.
Do you also recall
Yes, I'm listening.
also recall that on the 27th day of January 2001, you posed to a further statement on oath?
Yes, I recall.
These statement on oaths, what do you want this honorable court to do with them?
I would like this honorable court to adopt it as evidence in these proceedings.
And our witness adopts the statements on oath.
Yes, witness statements adopted, both. So,
We are grateful, sir.
yes. That's the one.
Right.
Yes.
Both of them are dated 27th.
Yes, these provisions are adopted as its evidence in chief.
We are grateful, sir. Now, on your paragraph 37 of your statement on oath, initial statement on oath, you depose to the fact of the existence of the contract of supply of POS machines. If you see that agreement, can you recognize it?
Yes, I'll be.
Lord, may I interrupt my learned friend with the greatest respect?
Yeah.
I my learned friend and I had discussed, in order to save time, that all the annexures that they have will be admitted in evidence. We have no objection to any of them, so that we can proceed with the cross-examination if my learned friend doesn't mind. That was the understanding. And we may as well just have the court mark the exhibits accordingly. I don't know if that's a convenient way to approach this.
My Lord, I just wanted the witness to identify the exhibits as admitted by court. But my Lord, in order to save time, I think the learner's suggestion is appropriate in the circumstance, as long as the exhibits are on record.
Yeah, no, we can jointly mark the exhibits. That's what I mean. We don't need to take the witness.
Since I have the documents you have, you intend to tender as exhibits, all listed out here, Mr. Udochi, and you listed them as annexures 1 to 10. Now,
Yes, the
learned state has said it's not objecting to any of them. So, if it's not objecting, instead of going through them one by one, I'm going to admit them and change. They will now annexure 1 to 10 will now be exhibits 1 to 10.
I'm grateful, my Lord. Grateful, my Lord.
Or we can use the alphabet C to now be exhibit C to C9. Exhibit C will be annexure 1, and then numbering down there goes to 9. So we have it as exhibit C to C9. Is that understood?
I'm grateful, sir. I'm grateful, sir.
Can I explain? And annexure 1 is now exhibit C. Annexure 2, exhibit C1. Annexure 3, exhibit C2. Annexure 4, exhibit C3. Annexure 5, exhibit C4. Annexure 6, exhibit C5. Annexure 7, exhibit C6. Annexure 7, exhibit C. Annexure 8, exhibit C7. Annexure 9, exhibit C8, and annexure 10, exhibit C9. Is that understood by the parties, please?
Yes, my Lord. We are grateful, sir. My Lord, in view of the admission of the exhibits on record, I tender the witness for preservation.
Right. Thank you very much.
I'll give you 10 minutes. Is that enough for you to do cross-examination?
My Lord, I will do my utmost best if all the documents are in. Mr. Talbot.
Yes. Starting right at 10:54.
As the court pleases. Mr. Talbot. Can you hear me?
Yes, I can.
Thank you very much. Can I take you to the first exhibit, which is now, it's marked, it was formerly marked Annexure 1, it's now Exhibit C.
Okay.
Can you display Exhibit C?
Yes,
yes.
That's it. Now,
Yes.
Can I take you to, let me ask you this first of all. These contracts, you executed it on the 1st of April, 2019. That's correct, isn't it?
Yes.
And by the contract, and I'm referring you particularly to clause 10, clause 10B, this contract could not be altered except, of course, in the same format in which the contract was created.
Yes, that refers to the rights and obligations of both parties.
Thank you very much. Now, you received a letter from the defendant, and in that letter, that's exhibit C1, addressed to you, right? Exhibit C1. In that letter, the managing director, Linde, was requesting for a late payments regarding the last obligation. There were 3 separate payments he was to make, but the last one, which was to be paid on the 3rd of January, I'd like you to just identify that letter and confirm that there was a request to pay that at a subsequent date. That's in paragraph 2.
There were post-dated checks given to that effect.
Yes.
We were to proceed with the post-dated for the last payment on the 3rd of January. Before then, we were given this letter informing us that there would be insufficient funds in the bank if we proceed with the letter. And so we had to give a 7-day grace to enable them update us on the state of things. This is because we already had an information from them that their payments are going to be quite flexible. And so we understood the dynamics of their payment timeline. So this was just done in good faith, giving them more time to perfect their obligations.
Correct. So you agreed to that request to extend the time within which they'll pay. Is that correct?
The time was not extended. The time was certain in the contract.
Okay.
The time was not extended.
That's fine. The time was not extended. Can I refer you to Exhibit C5 now, formerly Annexure 6?
Yes. Are you there?
Have you seen that letter?
Yes.
Now, that letter was addressed by your sales manager, Miss Jane. Is that correct?
Yes.
Can you read out 1, 2, 3, the 4th paragraph, please?
Following your request for additional time within which to meet your payment obligation in your letter dated 24th January 2020, we have resolved to grant you a 7-day moratorium.
Thank you very much. Can I now refer you very quickly to Annexure 8, now Exhibit C7. Now, by that exhibit, it is correct that and this is, I'm referring you now to paragraph 4, that the obligation to pay was adopted by a foreign German company to pay you what was being owed by Linde.
No,
Right.
I didn't get such a thing.
Can you read out the 2nd paragraph?
However, as a good faith measure and in consideration of our proposed long-term relationship, we are willing to make the payments on their behalf and recoup payments once they're able to do so.
Who was that? Who was being referred to as on their behalf? Because this is a letter written by, of course, Linde, and you've accepted that you received this letter. Who were they referring to?
I didn't receive this letter.
Well, look at the letter is addressed to you, and your counsel hasn't, no one has objected to it.
We were not to tender this letter. It wasn't written to me.
Well, it's now been tendered.
It's
all right. Let me ask you a second question. are you aware that a German company had accepted to meet that obligation on behalf of the defendants?
We were never aware of such assignment, because even the contract document states that such assignments should be done in a similar form as a contract. If there was such assignment, we'll have a contract document to that effect, and there is no such document to that effect.
All right. It is correct that you appointed one DG, Tauban, to negotiate this contract on your behalf and to do everything necessary to execute the contract. Is that correct?
Yes, prior to the formation of the contract.
And he did collect the first 2 checks on your behalf, correct?
Yes.
And you never communicated to the defendant that he did not have any authority to do so, to act on your behalf. There was never any communication, at least in writing.
The contract document states what should be done. So I assume that the managing director of the defendant knows what is stated in the contract document. All notices should be given to the
Yes, let me ask you that question again. You wrote a letter, and I'll fish it out now, telling the defendant that you were appointing DG to consult and to do everything that was necessary. And that is, let me refer you to Annexure 11, which is now Exhibit C10.
Yes, Mr. One.
This was a letter you wrote to DG, defining his scope of authority. Is that correct? Paragraph 2.
Yeah. Yes.
Now, can you read out the 3rd paragraph there, please?
Being your client, we will give you leeway in the negotiation of deal as far as our business objectives are met, which is the income.
Right. And you also communicated these facts to the defendants.
This negotiation we are talking about is prior to the formation of the contract, the negotiations for the contract formation, which was duly signed after all said and done by both managing directors. At that point, DG had no binding authority whatsoever. The contract form was the only binding document.
But it was after the contract that payments were made and the checks were delivered to DG.
The provision of how the payment should be made and in what manner were also provided in the contract. If you look at the contract, we agreed for post-dated checks. So
Yes.
they were all there.
The defendant's position is that you, by your conduct, you acted slightly away from the contract. You permitted DG to collect the checks even after the contract. You permitted DG to continue to negotiate with the defendants. You never, in any of these letters, you never wrote to the defendant to describe the limitations that DG may have in representing you.
The negotiations DG had subsequent to the contract were negotiations that were incidental to the performance of the defendant's obligations as stated in the contract, and there were no fundamental changes, just actions and negotiations incidental to the performance. That is why DG was the one who went to cash the checks, the post-dated checks already issued.
Did you, when you terminated DG's appointment on the 1st of February,
Yes.
2020?
Yes.
Mr. Eghobamien, your time is up.
Final question, this termination, was it communicated to the defendants?
DG is not a party to the contract. There was no need informing the defendant of DG's termination. It's an employee of the claimant company.
So you did not think there was any need to inform the defendants that the gentleman who was negotiating and interacting with the defendant had been terminated?
Negotiations prior to the dismissal of Mr. Deji, we already sent letters to the company on our own without Mr. Deji. So I was not even aware that they were still having negotiations with Deji. We were never told.
Well, look, that is all for this witness. I thank your lordship.
Examination.
With Neil, my lord. My lord, that's the case for the claimant.
Claimant may step down.
I'm grateful, sir.
Defendant's case now. Defendant, are you ready?
We are ready, my lord.
Witness?
Yes, we are ready. Now, kindly tell the court your name, what you do for a living, and your profession, please.
Kindly permit me to swear the witness in.
Oh, I'm so sorry. Thank you.
Do you wish to swear or to affirm?
I wish to affirm.
Okay. Kindly repeat the oath that is displayed on the screen, please.
I, Kim Landley, do solemnly, sincerely, and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
I didn't see the witness stand and affirm. Can you do that again, please? Can the witness affirm again, please? I need to see the witness.
I, Kim Landley, do solemnly, sincerely, and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
That's a huge prayer. The witness may sit down, please.
Thank you, my lord.
Okay. Yes.
Can you tell the court, please, your name, what you do for a living, and where you live, please?
My name is Kim Landley, and I'm the Managing Director of the Defendant in Disputes, ESPA Nigeria Limited, and I live at 10 Ring Road, Benin City, Edo State, Nigeria.
Thank you very much.
Just a minute. I'm not seeing the witness on the screen. Okay, she's up here now. I've seen her.
Right. As my lord.
Yes, I've seen her now.
My lord, please. Now, on the 19th day of February, you swore to an affidavit in Benin City. If you see a copy of that affidavit, would you recognize it?
Yes, I will.
Will the registrar be kind enough to display that? Now, are you adopting this as your statement, your sworn statement in support of your case in this matter?
Yes, I am adopting this.
What do you want the court to do with it?
I want the court to admit this as my evidence.
Yes, the position admitted as evidence in chief.
As the court pleases, the witness is all yours, my learned friend.
You have no
Yes, sir. Yes, my lord. If I may be guided as the time limit, sir.
Mr. Oghobamien,
My lords.
You uploaded some, front-loaded some documents attached to the witness disposition.
That is correct, my lord. That is correct. I have 13, although there's some overlaps, but I have 13 annexures, my lord. And I perhaps will just continue where my lord stopped earlier, which I think was C10, if I'm correct. I think there were 11 annexures. So we may start from, in the same order. We have
okay, so you want us to start from annexure 10? Leonard Silk?
yes, my lord.
Okay, so from annexure 1 to 9, annexures 1 to 9 is common to both parties.
Yes, my lord.
Okay, so I will admit from, yes.
Yes, my lord. To make it easy, we'll just come.
Come again, I'm not hearing you.
Yes, my lord. I said we'll just start from 10. In other words, the last exhibits we had earlier on, and the exhibits we now have, which reads Annexure 1, will now be Annex C11. Well, it will be a different letter.
Oh, it will not be C11. This is the defendant's case. So I read the alphabet D.
Correct, my lord.
So,
D. Annexure 10 will be Exhibit D. Annexure 11 will be Exhibit D1. As your lordship pleases.
Annexure 12 will be Exhibit D2. And Annexure 13 will be Exhibit D3. So the defendants, in essence, you are tendering 4 exhibits, correct?
As the court pleases, my lord.
Yes, that is beginning with Annexure 10.
Correct, my lord.
Mr. Udochi?
Yes, my lord.
Are you objecting?
No objection.
No objection. So the defendant's documents beginning Annexure 10 is Exhibit D, Annexure 11 Exhibit D1, Annexure 12 Exhibit D2, and Annexure 13 as Exhibit D3. Yes. Is that all for the witness, Mr. Oghobamien?
Yes, my lord. I had urged your lordship to accept this document, and I'm done with the witness. The witness is now available for cross-examination.
That's fine. That's fine. Mr. Udochi, your witness.
Yes, my lord. I will proceed with the cross-examination.
Yes, you have 10 minutes. It's 11:15 now. So you stop 11:25.
Can you be shown Annexure D1? Annexure D, sorry.
Annexure D is, okay. Yes, D. That's Exhibit D.
Yes, sir.
Yes. Witness?
Can you
Yes,
identify the documents?
Yes, I do.
This thread of email was a correspondence between Deji and you.
Yes, correct.
This correspondence was in relation to the suit of payment.
Okay.
The correspondence was in respect of what?
Sorry, I didn't get you.
This email thread, was in respect of what?
As in respect of the remaining balance for the POS machines agreements.
You are aware that Deji was an employee of the claimant.
Yes, I was aware.
You are also aware that Deji is not a director of the claimant.
Yes, I'm aware also.
Now I refer you to Exhibit C. Exhibit C.
Yes.
Exhibit C, claimant's exhibit, the contract for sale. Yes. Exhibit C was executed by the defendant.
Yes.
Can you are nodding?
I can identify this. It's the contract for sale of the POS machines.
Now, by virtue of clause 15 of that contract, can you see it? Clause 15.
Okay. Yes.
Because I suggest to you that that clause determined how notices and communications should go between the parties to the contract. You agree with me?
Yes.
That clause, I suggest you also eliminate communication between employees in both companies.
Mr. Udochi, can you come again with that question?
I said clause 15 of the contract of sale.
Yes.
Made stipulations on how notices and communications should go between the parties to the contract.
Yes.
Sorry? I didn't get your answer.
Yes, yes. It does prescribe the mode of notice.
Yes. Now, the communication I referred to earlier between Deji and you does not comply with clause 15.
It seems so. But before this contract was drawn up,
I didn't get the answer.
I said it seems so, but before this contract was drawn up, Deji was the one I was communicating with. And he specifically told me expressly in an email that he has been specifically instructed to negotiate with me.
Yes. Now, as we speak, the defendant is still owing 50 billion to the claimant.
Mr. Udochi, can you repeat that?
As we speak, the defendant is still owing the claimant 50 billion naira.
Yes.
Yes, that's undisputed.
It's undisputed, yes. Now, the alleged assignment of the debt to your partner, was the claimant a party to that assignment?
Sorry, can you come again?
The alleged assignment of this debt to your partner,
yes,
the German firm,
yes,
was the claimant a party to the assignment?
Yes, the claimant was a party.
Was the assignment in writing?
No, it wasn't in writing.
Yes.
You have nothing apart from this self-made email. It depicts that there was an assignment of the debt.
There was an assignment which was agreed to. The assignment was agreed to by Deji.
Now, Deji, in one of his emails to you, asked you to notify the board of directors for putting it on record.
Yes, he did.
Was that notification made?
Yes, it was made.
You have a copy of that documentation?
Yes, I do have a copy.
Is it before this court?
Yes, it is. It's the letter dated 2nd of January.
Dated?
2nd January.
Is it an exhibit? Is it an exhibit?
Yes, my lord, it is in exhibits. That is exhibit C2, I think it is. Exhibit C2.
That's the demand for payment of the third batch. Is that the document she's referring to?
Document, the letter dated 2nd January.
Exhibit C1, my lord, I'm sorry, exhibit C1.
2nd January, yes, 2020, yes.
Between you and who was it?
Yes, Mr. Udochi.
Dated.
Is that the document you're referring to, Mr. Udochi?
Exhibit C1, 20th March 2019.
No. C1 is 2nd January 2020. So which document are you referring to?
Now, in your exhibit, you did make this communication to.
Mr. Udochi, please, I need to get you right.
My lord, we are responding to exhibit C1.
C1 is not dated 2019, it's dated 2020. 2nd of January.
Sorry, document declaration of the suspension of presentation of checks. Where did you mark it? Sorry, sir.
Yes, suspension of presentation of check. Okay. Because you mentioned 2019, I was getting a bit confused. Yes.
That should be exhibit C1. Now, your communication to. Sorry, sir. Your communication to MD of by this document, you did not give a time frame when you will make payments.
Yes, we didn't give a time frame for making payment, but we did say we will return with an update within a week.
In your interaction with Deji, did you give a time frame?
No.
When did you make a commitment to pay in March 2020?
Yes, we did make a commitment to pay in March. Yes, we did.
Did you honor that commitment?
Sorry, I didn't get that.
I said, did you honor the commitment to pay in March 2020?
I honored the commitment.
You paid?
It was beyond my powers due to circumstances that were unforeseen. We couldn't honor the commitment.
When do you intend to honor that commitment?
Like I said, the commitment is not something we are personally withholding. It's dependent on payments we receive from our partners, which has been held down due to circumstances like COVID and the rest, the lockdown.
At the time you entered into the contract of sale, did you notify the claimant that you had a partner that was financing it?
Yes, we did.
Is it contained in Exhibit C?
It was contained in an email sent to Deji.
Is it contained in Exhibit C? That's a question to you, please.
No, it's not contained in Exhibit C.
Your German partner is signatory to Exhibit C?
I didn't get that, please.
The German partner, Registrar, yes. Is that company a signatory to Exhibit C?
Is the person a signatory to?
The company, your German partner, major partner,
yes.
Is that company a signatory to Exhibit C?
No.
I suggest to you that this your assertions about assigning a debt. Yes, my lord.
Time off.
And just this question so that I'll round up, sir. With due respect, sir. It's just. Am I permitted, my lord?
Yes, go ahead. But
yes. I suggest to you finally that these issues of an assignment of debt to your German partners, your enemy to pay, are matters, are an afterthought to avoid the obligation to the claimant.
No, it's not an attempt to avoid it, because flowing from the facts and the letters, the phone calls, and the conversations that has ensued, it's obvious that we have been trying our best to make sure that we make payments.
Thank you.
Is that all?
That's all, sir.
Re-examination, Mr. Eghobamien?
No re-examination, my lords.
Is that the case for the defendants?
That's the case for the defendants.
Having heard the case for the claimant and the defendants, the parties are hereby directed to file and exchange their final written addresses in accordance with the time frame permitted by the rules of court. That will be 21 days for the claimants, within which to file and send his final written address. Upon service, the defendant has 21 days to do the same. And then, the defendant first. The defendant first, then the claimant, and then the defendant has 7 days within which to file a reply on points of law. So that will be 21, but I will have, Counsel, can't we have reached time so we can deliver judgment on time? So I can deliver the judgment.
As my lord pleases.
As the court pleases.
Can we have reached time? It's a very straightforward matter.
Yes.
7 days each.
My lord, I would just need 5 days to file my file my submissions, written submissions, just 5 days.
Direction on abridgment of time. Defendant is given 5 days to file his final written address. Claimant?
My lord, we will take the same 5 days.
Okay, same 5 days. And then the defendant, you have 2-3 days for reply on points of law. Is that all right?
As the court pleases.
Okay,
As the court pleases.
I'll give you 3 days. That will be 5 and 5, 10, and 3, that's 13 days. So in a fortnight from today, that's 14 days from today, we'll be back to adopt the final written addresses of the parties. Registrar, What date is that? 14 days from today. Can you guide the company? Registrar? 14 days from today. What date is that? Today is the 29th of March.
My lord, that is going to be on the 12th of April 2021.
Okay.
Yes, my lord.
This suit stands adjourned to the 12th of April for adoption of final written addresses by Counsel.
As the court pleases.
Court pleases.
In the absence of any other matter on the list, the court will rise. Thank you, Counsel.
Court.